Hello and welcome to this Fieldfisher series of Get Data Protection Fit. This is part 4 of Module 1, and in this session we will be discussing what are the rights of the data subject and when can they be used. My name is Lorna and I'm joined by my colleague Alexander Gaye. We're both lawyers specialising in data protection in Fieldfisher's Privacy, Security and Information team. So, for those of you who have joined the first 3 parts of this Module 1, you will have looked at the key concepts, the data protection principles, and the grounds for processing personal data. And what you'll begin to see in this part 4 is how interwoven the elements of data protection are. So we'll be referring back to some of those concepts and principles that you've learnt about, and that's why it's really important to understand the principles and fundamental concepts, because it's very much a layered approach and it's important to have a solid foundation on which to build. If you haven't listened to parts 1 to 3, that's not a problem, and those sessions are also available on this YouTube channel on which you are listening to this session.
Thanks, Lorna. So hi, I am the other voice, Alexander Gaye. Our learning outcomes today are on the screen now. So by the end of this session, you will be able to understand the different data protection rights under data protection law, specifically the GDPR, how you would make a request as a data subject, and how you'd respond to a request as a data controller. If you remember the roles back on part 1, you'll also remember the data processor role. We're not going to be discussing that one today, but they do have a role in data subject rights. Their role essentially is to assist the data controller. So if you remember from the earlier sessions, the GDPR is the core piece of legislation. It's broken down into chapters, and within each chapter contains many articles. So you talked about the chapter 2, the principles, in the earlier segments 1 and 2, and now we're talking about chapter 3, which contains the rights of the individual. That's made up of articles 12 to 23. Individual rights are at the center of the GDPR, and they're seen as fundamental and very importantly viewed by the regulators. Some of these rights existed under the old law and remain under the GDPR. Others have been expanded, and there are some brand new ones. We've put on the slide now the list of the rights. I'll just go through them briefly. So you as a data subject have the following: a right to information about the processing, a right to get a copy of your own personal data, plus some additional information. That's commonly called a subject access request. You may have heard of SARS or DSARS. The right to correct your own personal information if it's wrong. The right to erasure, which is also known as the right to be forgotten. The right to restrict the processing of your data. The right to data portability. The right to object both to processing in a general sense and specifically to direct marketing communications. And finally, the right not to be subject to automated decisions.
And thank you for that, Alex. So now we're going to focus on the actual key concepts specifically related to data subject rights. These are covered in Article 12, and don't be overwhelmed by the different articles. It's just good to get familiar with the different articles, because even now in practice, as the GDPR is almost 2 years in place, we are forever looking at the finer detail of the regulation. So these concepts are provided for in Article 12. And also we've got some great slides or images on this slide. So previously, and there will be some comparisons to the old law, like Alex has already said, how some of the rights did exist before. So in the UK, you would have to pay £10 previously, and that was often seen as an obstacle, or certainly it may be something that dissuaded people from making certainly a data subject access request. But now that is free. There's no initial payment required unless your request is manifestly unfounded or excessive. There's also a time frame in which for the controller to provide that information to you, or to respond to one of the rights requests you have made. And that deadline is, in fact, it's without undue delay, and in any event within 1 month. So there is an emphasis on the time to be of the essence, or certainly not for the data controller, the person, the company that you're writing to just sit on your request, but to deal with it as soon as possible, and then within that 1 month. It can be extended for a further 2 months, but there needs to be some complexity, and also if there had been a number of requests, and those could be considerations for extending that deadline. So, for example, it's not sufficient for a data controller not to know where their data is, and simply having a large volume of data by itself is not enough. It's more about the complexities, so perhaps where the difficulties are when we come later to talk about exemptions, and why there might be difficulties with the request that has been made, but it needs to have some complexity to it. Also, it's quite important, data protection, the word key there is protection, and it's all about keeping the individual's data secure and not allowing any unauthorized access. So a controller will generally verify your identity before being able to comply with the request, and it's only once the identity is verified that the 1 month timing will start. Also, how that identity is established may vary, and it will often vary as well depending on what type of data you're requesting. So you'll have heard in the various previous sessions how data is categorized into non-sensitive data and sensitive data, or special categories of data. And so if it is, for example, health data, some very sensitive data, the verification process may be a bit stricter. And also, how do you actually make the contact the controller? Well, that's often in the privacy notice. Privacy notice, something we'll be coming on to in the next session. But when you kind of take a look at that, any e-commerce site that you're dealing with or making an order from will have a privacy notice, and often within that privacy notice you will see headings such as "What are my rights?" and there it will tell you about your different rights. So just good to see these things in real life and how they are out there, and given how data is so important today, or there's so much data, these are just real examples of what we're seeing all the time. And so we come again to the balancing test, because data protection rights, as you will be familiar with and particularly covered in part 1, is not an absolute right. Article 23 we'll also discuss how there are certain restrictions on providing the rights to a data subject. And just to pause here and to say, Alex and I, we may interchange with individual or data subject, and the terms are quite interchangeable. So just so you're quite familiar with the interchange, because any new subject, there is a lot of language that is quite unique to that particular subject. So certainly, the data subject, that's me, you, the individual. And what type of restrictions would allow a data controller not to comply with your request? So say, for example, they may have a legitimate need to retain the data. So, for example, if there was going to be any litigation, a court case, for example. Also, there will be times when, for accounting purposes, the controller will need to keep the data. Also, the data may also contain somebody else's data, referred to as a third-party data. So therefore, you have to be careful not to release anybody else's data when your data is requested. So it's about balancing your rights against those rights of other people, wider society, the controllers themselves. And so we will focus on the rights now, but you always have to remember, just because you have the ability to make the request does not always mean it will be straightforward.
Okay, thanks, Lorna. So I'll talk about one of the key ones here, the right to access. So say, for example, you have a Facebook account and you want to know what all the data Facebook has about you. You can make an access request. Then the right is sort of twofold. You have the right to information from the controller, and you have a right to a copy of all the personal data they hold. So firstly, the information, the controller, so Facebook in that example, will have to confirm whether or not they're processing your data, tell you the purpose of that processing, tell you the categories of data they are processing, tell you if they are sharing it with any recipients, including any recipients outside of Europe. There are rules on data transfers, which we'll be discussing in part 6 of module 1. The controller will also have to tell you the storage period, about any other rights you may have regarding that data, and the source of the data if it wasn't you. And the second part is a copy of all that data. So you can ask Facebook for a copy of all the data that they hold on you, which can be a huge amount, hence the pile of files I put on the screen. Particularly now we live such digital lives where so much of our lives are recorded. It's no exaggeration, say lots of our clients have received requests where records will number into the hundreds of thousands for an individual. But the thing to note, as Lorna introduced, is the rights are balanced. So you don't have the right to the document itself, but only your personal data, which is contained within that. So often if person A makes a request and it contains data of person B, the controller will have to do some kind of balancing exercise, which may end up redacting quite a lot of personal B's information, as indicated in that lovely redaction image there. Yes.
And if I may just explain redaction, I once came across someone who was highly intelligent, had various degrees and had never known the word. They were a non-lawyer, didn't know the word redaction. So means where it's blacked out is to redact. I think anyone who does any legal training becomes quite familiar with the word, but just so for anyone listening who is unfamiliar, I just thought I'd explain that. Alex, very familiar to you and I, but not necessarily to non-lawyers who may be listening. So also, now moving on to the right to deletion, also has the nickname right to be forgotten. However, as we'll see over this slide and the next, that can be quite a misleading phrase. So similarly, taking the example of, closing a social media account, or perhaps more relevant to this particular example I will be sharing, is if, for example, you were coming up details about you in a search engine, you tapped in, say, let's just say my name, Lorna Cropper, and travelling, and if I was to get some particular search results on that which we didn't like or weren't necessarily relevant, or I withdrew my consent, would I be allowed to see it, or to ask a search engine such as Google to delete those? So there are possibilities to have your erasure deleted. For example, if the data is no longer necessary, or the data subject withdraws consent. Also, if the data subject is also objecting, which we will come on to discuss, but there must be no overriding legitimate ground to that objection, or if it's required for legal compliance to erase. But again, here we have a good illustration of the balancing test again, because that deletion cannot happen if balanced against the freedom of expression, the data subject's rights don't meet that balancing test and don't override the freedom of expression. Equally, it may be necessary for legal compliance, and then also public interest, and similarly for archiving purposes. So, as you will remember, my surname is Cropper, and the irony behind the right to be forgotten is trying not to become a cropper, so not to fail in what you're setting out to do, or what's known as the Streisand effect. So, which is the name is taken from Barbara Streisand, who, when wanting to remove images or wanting no photographs to appear about her home in Malibu, it had the unintended consequence of bringing far more attention to that information than could ever have been imagined. Similarly, and this is a big legal case, so please don't be put off if you feel Alex and I are giving you quite a bit of law in this session, but this particular case, Google against the Spanish Data Protection Authority, the Agencia Española, the AEPD as it's known, and then Mario Gonzalez, is quite a famous case for many reasons, but in particular because Mr. Gonzalez wanted to have his search results deleted from Google. But the effect now is his name is forever synonymous with his request and with data protection, and it will appear in every textbook for the rest of history, no doubt. And so what you may have seen in some of your search results is this little explanation and tagline at the bottom of search engine results, which says some results may have been removed under data protection law in Europe And that is particularly in relation to this right of deletion. But then equally, you get some newspapers who are actually keeping a whole log of all those links that have been deleted. So it's almost like, can you ever be forgotten? And given people's digital footprints, it is quite hard. But if you do have a reason, and particularly where those rights to erasure, as we've got on the beginning of this slide, apply, providing they are, the balancing test works, well then yes, you can. But just to know, it's not a foregone conclusion, as I hope I've been able to illustrate here. And then worst case scenario, you do get the Streisand effect. And so also, just another example is the right to rectify. Certainly, if you apply for credit, this is often used in credit reference agencies, and you'll be asked if you apply for, say, for example, a loan or a credit card. And there are the agencies such as Experian who will allow you to check your details. It might say that it might not have your addresses for the last 3 years correct. And so if you want to, or say, for example, it recorded you as bankrupt, you can review those details that they are keeping of you and then request that they are rectified. Or similarly, I had an example myself this week where I was expecting to have quite a number of loyalty points with a bookstore, and I was hoping to get a complimentary book from my loyalty to them, but my loyalty card was not syncing. But the reason for that was because my email had been spelt incorrectly on the account, and so I asked them to rectify that, and hey presto, I now have my correct amount of loyalty points. So it is a used right, but not necessarily as much, certainly, as the other two, but very useful and very necessary.
Thanks, Lorna. So those are the three big ones in which we have all seen a huge increase in the number. The following rights are far less common, so we're going to go through them a little bit quicker. In fact, we asked our large team, there's about 60 or more privacy lawyers in the Fieldfisher team across different jurisdictions, whether they'd received any of the following requests for clients, and only a handful of responses came back. Likewise, Lorna had a little poll on Twitter, and we got very few people who said actually they've received them. However, they are valid, they are in the GDPR, so we will take you through them now, but at a slightly faster pace. So the first one of the sort of less common rights is the right to object. And this is split into two. So you have firstly the right to object to processing in general terms, where the legal basis is either the public interest of the controller or it's in the controller's legitimate interests. You remember legal basis was discussed in part 3. And in either of those, the controller will need to demonstrate compelling grounds to override your objection. The second aspect is you have the right to object to direct marketing. You probably notice in any marketing email you get a little unsubscribe link at the bottom. That's how you can exercise that right. And I should quickly say the direct marketing, that's an exception to what I've just said. That one is very common. And it's also an exception to the balancing test because that's an absolute right. If you object to marketing, the controller must respect your objection.
So thank you, Alex, for talking us through that. So now we come on to the right to restrict processing. So, no entry. So when can you request the right to restrict? So again, similarly, not often seen, but need to be aware of it. And it can be requested when you contest the accuracy to your data. Also, if the data's been processed unlawfully, so think back to those principles, and also the data subject doesn't want the data to be erased. If the data is required for legal claims, it can be restricted, but also if it's pending an objection to the actual processing of the data. So thinking back to that slide in part 1 and all the different reasons why you can have your data or what data processing is. But then if you object to any one of those elements, you could request that your data is restricted whilst that objection is going on. Again, thinking balancing test as well, and also different restrictions. So also, if there's no processing, there won't be no processing unless you have consented or it's necessary for legal claims. And in the UK, for example, contractual and litigation claims have a limitation period of 6 years. So sometimes there can be a period of that length, 6 years, where data is kept.
Okay, so next we have the right to data portability. So in this one, let's say you have all your photographs styled on one online photo system and you want to move them to another, illustrated by these two servers, seemingly in heaven. You have the right to receive your data in a structured, commonly used, machine-readable format, and you have the right to transmit that to another controller without hindrance, or you can ask controller A to transmit it directly to controller B. However, it's not quite as useful as it sounds, because it only applies where the legal basis is either consent or where processing is necessary for a contractual purpose. And often the controller won't be basing the processing of your data on consent, so the right is rather limited. It was supposed to be a real game changer, but it hasn't really taken off yet. Then you also have the right to be informed about what processing is taking place about your data. Now, this is a whole subject in and of itself, so actually part 5 of this series is going to go into this in a lot more detail. And finally, you have the right to be free from automated decision-making. So the classic example here is you apply for a mortgage from a bank, and the bank uses a computer algorithm to decide whether or not you're eligible. And as a result of the computer, the bank says no, or a sorting hat decides what schoolhouse you should be in. So you have the right not to be subject to a decision based solely on automated processing, which produces legal effects or effects similar to legal effects. And as usual, there are some exceptions to this, but they're quite narrow. This only doesn't apply if the decision is necessary for the performance of a contract, it's allowed by a local law, or if the data subject explicitly consents, which is hard to really imagine in practice. And all three of these also have to have some safeguards. So, for example, you may have the right to have a human intervene. So you could say to the bank, I don't want the robot making that decision. I'd like a person to review it. It is set out as a right of yours, the individuals, but in practice, it's more the obligation of the controller to make sure they're complying with this.
Okay, so now we're coming towards the end of the session. And what we hope you have been learning throughout this, and what you should now be better able to understand, is the extent of data subject rights under data protection law in Europe, and just the different rights that are afforded to individuals, how to make those requests as a data subject, and then also as a data controller. And if you were, for example, employed by a data controller, it's essential that everyone can recognize a data request as well, and particularly given the time frame in which they needed to respond by. And just picking up on the reference of Alex's to how notice is a topic amongst itself, so too is, for example, responding to a data request. And later in this series we will have a session purely just on what you do when you receive a subject access request. So for those wanting to get ahead and looking to part 5, what needs to go into a privacy notice, when you're next shopping or browsing online, do look at the website and see what privacy notice. In fact, you don't need to be buying anything. You could be streaming media or looking at the news. Every website will have a privacy notice. And why don't you, whilst you're there, look at what your data subject rights are within that, with what that controller is offering. So thank you for joining us today. If you do have any questions arising from this, here are mine and Alex's contact details. Just as you've probably heard from the other sessions you've listened to, we are a collaborative team providing strategic and actionable privacy solutions. And it's a real privilege to be working in data protection today. It's a very exciting area of law, and certainly one that is extremely fast moving and is impacting on everything and all our ways of life, given the whole digital economy. You're familiar with the YouTube channel. Also, at the bottom there is access to our Fieldfisher blog. So anyone wanting to gen up on data protection and just get familiar with the different concepts and how they're being applied in practice, you can sign up to that blog. And also, what's very good is the ICO, so the Information Commissioner's Office, which is the UK Data Protection Authority. They also have a very good page on your data matters, which is all explaining in plain English as well how data subject rights are requested, and also how they are enforced, and also how they are complied with by the data controller. Obviously, as the data protection regulator, there's every aspect of information on that site. And similarly, as in practice we are constantly referring to the GDPR itself, we are also looking at what the guidance the ICO has given us. And just on that, and my reference back to interchangeable phrases, you may hear, quite exceptionally I have to say, but just in case, some people do refer to the ICO as ICO. So if you ever hear that, don't be like me and think, oh gosh, is that an institution I haven't heard of? No, it's some people calling the ICO ICO. Well, thank you very much indeed, and I wish you every best of luck on your data protection journey. Thank you.